Good morning, everybody. How are you guys doing? Happy Wednesday. It is good to see you. So, what do y'all think about life estates and fee simples? You okay with it? No, I see some. I see some no's. Not a lot of smiles there, but okay. Well, hopefully, we'll have you smiling by the end of the semester on this stuff. At least like smiling in the way that you're like, that kind of smile.
Professor,
Yes.
do you think we'll have time to go over one more example? You walk through one more example of fee simple.
Yes. Do you
Okay,
have an example in mind, or do you want me to make one up?
I want you to make one up.
Okay. I actually already had in my outline for the day, walking through, even going back through the examples that we did on Monday, tweaking them a little bit. So I want you all to feel free, and I encourage you to stop me on this stuff. For this is a little trickier, I think, online because when I do possessory estates, I'm just so used to using the board because I think it's really important to have these examples up on the board. So I'm going to try to use the PowerPoint share screen, but I want you, I'm going to rely on you to stop me when you're lost. So please do that. So I appreciate that, Shatavia. Okay. So let's go ahead and pull it up. I'll be looking for your hands, etc. And so this is what we had going on Monday. And basically, this is hold on, I'm trying to get my desktop organized here. So this is like the overview. This is the simple stuff. And I want you to look at this chart, and I want you to sort of absorb this chart, because I'm going to tell you that if you follow the chart, then all of these things are answerable questions. It just is going to take practice with these examples in order to understand how the chart functions. But for example, if you ever run yourself into a life estate and you end up in this box on the chart, so you see a 2A for life. Well, when I'm asking the question, which is the question that I will ask, what interests are there existing as to this property? And you see that there's a 2A for life, so you know that there's a life estate. Never stop there. Know that the chart is going to take you all the way over to the side, and it's going to remind you that every time there is a life estate, there has to be a future interest of some sort. Sometimes it's going to be a reversion, sometimes it's going to be a remainder, but the point is there has to be at least one. Okay, at least one future interest attached to a life estate. By definition, a life estate is not a permanent forever interest. That's just a fee simple. Okay, only a fee simple doesn't have future interests. Anything less than a fee simple is gonna have a future interest of some sort. So if you take your chart, then you go life estate, okay, I know there's a future interest, and then you'll look, and let's say it was this one, 2A for life. What you're looking for is, has that future interest been given to someone else? Here, the answer is no. That means it has been retained by the grantor, so what you're dealing with is a reversion. And we did that, not there, but here, okay? Whoa. 2A for life, then there is no future interest given away, so we have a life estate and a reversion. If we had 2A for life, then to B, who has what interests? Life estate. We know there's a future interest. Here, is it given in 2A for life, then to B? Is it given away? Yes, it is. Therefore, it is this kind of future interest, a remainder. And so if we go back over here, we're looking at this one, 2A for life, then to B, who has what interests? A has a life estate, B has a remainder. And then the sort of crucial sort of next question is, what happens in either case when A dies? What does that reversion in this example and the remainder in this example, what does it mean? What it means is at the end of the life estate, that future interest, poof, becomes possessory and becomes a fee simple. So just like the son in Gruen had a remainder, and when his father died, it became fee simple in that painting. That's exactly what happens in these examples here. The future interest holder, B in this example, O in this example, takes fee simple. Okay? We good so far? Okay. So let's go to this one. This is a per otra V life estate. So I don't know, Shatavia, you wanna work with me on this one for a second?
Yes, sir.
Okay. So the question is, this is a conveyance. O conveys to A for life, for X's life, then to B. And so the question is, who has what interests? So what do you think here?
X has the life estate, and then B will get the remainder if X dies.
Okay, so that's what you said. So let's look at it. Who is it going to?
To A or X.
So what does A have? If in your answer, X has a life estate, B has a remainder, what does A have?
That's where I'm confused.
Okay, good.
You said
So
2A for X.
2A for X's life,
Mm-hmm.
then to B.
So I get that B is the remainder, right?
Yeah,
is that correct?
this part's right. B has a remainder. So I'll give you a highlight on that. Boom. Okay. But this isn't right. X does not have a life estate. So that's why I'm asking, what does A have? It seems like A has something, right? Because it says 2A. That sounds like 2, like you notice that the word 2 is going to be crucial here, right? 2A, then 2B. It's like 2 is the trigger that there is an interest being given. So it seems like A has something. What do you think A has?
Maybe A has I don't know. Maybe A has the life estate.
Okay, so I hear A life estate with some question marks. Now, so let's look at X and let's see if this makes sense, that X has a life estate. Is there a 2X in this language at all?
No, sir.
So what do you think X has?
Nothing.
Nothing. Okay, so you're out. X has nothing. And A has a life estate. I'm going to erase your question marks and say A has a life estate. But the question is a little bit different than a typical life estate, which would be like 2A for life, right? 2A for life is attached to whose life, Chatavia?
A's life.
A's life. So if it says 2A for X's life, then whose life is the life estate attached to?
X's life.
Great. Okay. So this is called a life estate per otra V. You don't ever really have to put that. I'm just giving it from a labeling standpoint to distinguish it from a more typical life estate, which is just attached to the life of the life estate holder, the person who has the life estate. Okay, so A has the life estate for the length of X's life. That's a per otra V. And B, you were right from the beginning, has a remainder. Okay. So other questions on this before I start moving forward with what happens with this one into the future. And as y'all are thinking of questions, know that this is exactly how the conveyances show up on the exam. I give a conveyance. I have to confess to you that they're going to be a lot more complicated than what we're looking at right now. I give a conveyance. Question A is who has what interest at the moment of conveyance. Then I give some facts. this happens, that happens. And then question B is now who has what interests? You know, after those facts have happened, who has what interests? And so that's exactly what we're modeling here as we're going through this. So before I start adding facts into this, we're just now at this point talking about the moment of conveyance. Are there questions on this one?
To have the remainder, is that the same thing as a fee simple? Obtain a fee simple over
Nope.
the interest?
Nope.
Okay.
Okay, so you might eventually get a fee simple out of a remainder, but at the beginning, the remainder is just a future interest. So a remainder is like what the son had in the Gruen case. So he didn't have possession. He couldn't do anything with the painting during the life estate holder, his father's life, but he had a future interest. And that future interest meant that at some point in the future, he would be able to take possession. So in this example, we're going to see, in the example we were just working through, we're going to see, yeah, the remainder might eventually become a fee simple, but it is not a fee simple. Okay. Shadhavia, is that answering your question?
Yes, sir.
Okay. So note that it's and maybe this is a good point to make here. Every future interest, like the remainder in this example, is actually, let me turn off the highlighting. I'll do it in a second. Every future interest has a possessor, or will become, or so every future interest has the promise of someday becoming a possessory interest. So B's remainder here has the promise of someday becoming a possessory interest. A possessory interest is an interest on this side of the chart. A future interest is an interest on this side of the chart. So every remainder or reversion has the potential at some point to become this when things happen in the future. So, you know, if we come back to these examples, to A for life, then to B, the remainder that B has in that example at the time of conveyance is just a remainder. It's a future interest. But when facts happen and the world moves forward and then A dies, well, then it becomes a fee simple. So at the moment of conveyance, it was just a remainder, and that future interest had the potential of becoming a fee simple someday. And then here we're talking about when that someday arrives, it does in fact become a fee simple. Okay? So let's add some facts to this one. Now this is going to get a little tricky. What happens when A dies in this example? The life estate lasts for the life of X. So what happens when A dies? Anybody want to take a stab at that?
So would it revert back to O when A dies, and then it would go to B after X dies?
So Jasky is saying maybe it goes back to O for some interim period of time prior to X dying, because we know, and Jasky, what is it that's making you say when X dies, it's going to go to B?
Because B has the remainder.
And that remainder is attached to what?
X's life.
To a life estate that is connected to X's life. Okay. So the second part of what Jasky has said is exactly right. When X dies, the remainder will become fee simple, and B will take the property. Okay. So that is actually the more straightforward part. In some ways, it's exactly like these. Okay. These were connected to A's life, and when A died, the future interest holder took fee simple. This one is connected to X's life, so when X dies, the future interest holder is going to take fee simple. And so Jaski also said, and let me just write out what you said, that when A dies, O will take over the life estate for X's life. And at that point, let's just say before X dies, at that point, what does B have, Jaski?
The remainder.
Right, it's the same. There is nothing that has happened here that affects B's interest. So my question is, what has happened that has affected A's interest?
Death.
Death of A, right?
Yes.
And so was A's interest connected to A being alive?
No.
There's two answers to that question, right? There's the yes, A has to be alive in order to have the interest, but the other answer is no. So when you say no, what do you mean?
Yeah, I meant to, I was going to clarify, but you went into it.
Yeah, so no. Why not? Why is A's interest not really connected to whether A is alive or not?
Why is A's interest not connected? Because because it's a life estate for X's life,
Mm-hmm.
but he is interested because a dead person doesn't have interest.
Correct. So he is interested, certainly, but his interest is it's not really relevant. And so you're recognizing when you say it goes back to O that A can't keep it because A is dead, but that the life estate is still there, right? The life estate is a stick that was created here and is connected to X's life, and it has nothing to do with A. If A had sold this life estate and then died, then the other person, whoever he sold it to, would be holding the life estate for X's life. Okay, A could sell the life estate. So, if instead of what happens when A dies, I had said what happens if A sells their life estate to somebody, you would say it just becomes that person's life estate. Note that A can't sell B's remainder, but A can sell the sticks that A has, and therefore it's transferable, it's alienable. Okay, so Jaski, your instinct is to say, well, I don't know where else it would go, so I'm going to have it go back to the grantor, the O character in this example. So that part is wrong. So remainder is right, but it is wrong that O would take this back. So Jaski, let me ask you this. What would have happened what would have happened if it just said to A, it was just a straight fee simple, and then A died?
Then it would go to the state, or
Why?
Because because A didn't give it away, but A can't keep it. So without like a will or something that guarantees, his kids get whatever he has or whatnot, it would go to the state.
So not quite. You're in the right place. Can somebody help me? If it's 2A, it's just a fee simple, and A dies, what happens? Jaski has already kind of pointed out what actually is going to happen, and potentially it might go to the state, but it will only go to the state in certain circumstances. Tierney, I know you had your hand up before this, and maybe you were going to ask a question rather than answer this. Is that?
Yeah, but is the word you're looking for escheat?
Well, that's the word that Jaski's looking for, but not that's only going to happen if what's the case? Alana?
So if there wasn't, it only happens if there aren't any heirs. So if there's not a will, we would look at the intestate succession.
And if there's no heirs, then
it would go to the escheat.
Right, it would go to the state. So if it was just 2A for life, just 2A, and it was a fee simple to A and A died, the first place we look is the will, and we say, who has A given it to in A's will? If they've given it to charity, then it goes to the charity. If they've given it to me, then it goes to me. If they've given it to Jasky, it goes to Jasky, whatever. If they don't have a will, then we look at the intestate succession statute. And generally speaking, we're going to see, are there any heirs that A has? If A has heirs, it's going to go to A's heirs in some form. And we don't need to know the details. So then this is where Jasky's answer is at least in part correct. If there is no will, and if there is no heirs or are no heirs, then it would escheat to the state. So there's three possible options to what would happen if it was a fee simple and A died, okay? And so in any event, or any of those options, it goes back to the grantor. Jasky? No. So that is why in this instance, it doesn't go back to the grantor either. So if I've told you that if it's a fee simple, it either goes through will, through intestate succession, or escheats, you know, in that order, what do you think happens with A's life estate when A dies?
It does the same thing.
It does the same thing, okay? So it falls into A's estate, okay? So it will be distributed through will, intestate succession, or escheat, okay, in that order. First, if there's a will. Second, if not, then to the heirs. And if no heirs or no will, excuse me, then it would escheat. In no circumstance would it go back to the grantor. The grantor is done with this property in this particular example, okay? And then Jasky has already answered the next part, which is what happens when X dies, okay? What happens when X dies is it goes to be in fee simple, okay? All right, Tierney, your question.
So I know it's a lot of variables in this. So I want to know what is O? Is O just the grantor? Or okay.
That is
Because-
it.
So why do you say O instead of X?
Why do I say O instead of X?
Yes, like in the last example, you had O and then
Oh, that was Jasky's answer.
yeah, that was Jasky's answer. So
It was wrong.
yeah, I know, but okay.
Keep trying. So let's get it straight. So O has the bundle of sticks before any of this stuff happens. O takes the bundle and says, okay, A, here is your life estate, and B, here is your remainder. And at that point, there are no more sticks held by O, and O is completely absent from the rest of this story. They are out. They had a bundle. It was great. Now it's gone. And that's the end of O. So unless there is some sort of reason that O has been, that O is still in the story because they have maintained some sort of interest for themselves, then O is out of the story. And so the reason before, when I was working through, and I used O as an example, or as a potential answer here, it was what Jasky had said, and then I was pushing back and saying, well, no, it's not O, right? So I put here O, take over the life estate, but really now I should go ahead and mark that through and say, no, that's not correct. So I was putting his answer up there, and then we were working through trying to establish why this is actually the answer. Is that helpful?
So O is X, right?
No. No.
No?
X is X. O is the grantor. X is just some random person that is alive until here. Then they die. So O is O. Almost always going to use O as grantor. So I mean, would it make it any better if I just gave names to these people, like Daniel gave the property to Tierney for Jaski's life, then to Abby. You're Abby. I just randomly brought you in because you're at the top of the of my participants list here. In that example, Daniel is the grantor. O. Tierney is A. Jaski is X. And Abby is B. And so you can see we have 4 different individuals involved in this. The grantor, me, the life estate holder, you, the remainder holder, Abby, and then Jaski, who has no interest in this property, but it has been connected to him, his life, his being alive.
Okay, I understand now. He doesn't have any interest, just some random person.
Exactly.
Okay.
Exactly. And so you might be wondering, like, why would anybody do that? It might happen in a situation where there is children involved. So you might say it goes to my wife or to my child so long as my wife is alive, and then to the charity or something like that. So, you know, you're accounting for things that happen. You know, it's just a way to control the property by connecting it to somebody's existence. And it seems a little random that you would give a life estate for someone else's life. And in fact, it is somewhat unusual. But it could happen in those kinds of examples where you want, you know, usually you want the child to have it, but only so long as something, you know, the other parent or somebody else is still living. And we're going to see that in reality, life estates aren't used that often in terms of what's called legal life estates. What's much more common is trusts. And so a lot of what we're learning here is not actually going to function the way that we're talking about it. It's going to actually function within the bounds of a trust. But the concepts are all identical. We good? I saw a couple other hands, but I just want to, let's see. All right. Well, let's move into white versus brown. I promise you guys we're going to do more and more and more examples. Oh, Annie, yeah.
Sorry, I raised my hand kind of late. A life estate is alienable to the extent that it doesn't alienate the future interest? Any future interest? Okay.
Yep. So just so everybody's clear on what that question meant, a life estate can be transferred, can be sold, can be given away, can be inherited through will, all of those things. The sticks you have can always be alienated. I want y'all to sort of hear that, right? Generally speaking, the sticks you have can always be alienated, even though it is just a life estate. What you cannot do is sell, put in your will, give away, intent, delivery, acceptance, whatever, interest that you don't have. So if we go back to our example here, let's do the more simple ones. To A for life, then to B, who has what interest. A has the life estate and B has the remainder. Annie is saying, can A sell their life estate, right? Is that what you're asking, Annie? And the answer is, yeah, A can sell their life estate. But what A cannot do is sell the life estate and the remainder. A can't sell the full bundle because A doesn't have the full bundle. And so this is actually part of what happens in the Baker versus Whedon case, is that Anna wanted to sell the full property, but the remainder holders did not want to sell the whole property at that particular time. And so there was this conflict. So Anna could sell the things she had. She could sell a life estate, but a life estate is far less valuable than a fee simple because it has a duration, an end point. So hopefully that is taking care of the question. Yes?
Yeah, thanks.
Okay. Other questions, Sarah?
You may have already answered this. I'm gonna try to tread carefully, but what if there's reversion and remainder? Who gets it when A dies?
So hold that question. It is possible that there is a reversion and a remainder, but only where we have what's known as a contingent remainder, and we haven't yet talked about contingent remainders. So, so just hold off on that. Just know that we will answer that question one day.
Okay, cool. I'm fine.
Okay. Hopefully you'll still be able to sleep. Maybe we are putting you to sleep, in fact. Okay. Other questions? All right, let's talk about White versus Brown. We'll see some of this in action. So let's go with Benjamin. Benjamin, you go by Benjamin or Ben?
Either's fine.
Well, which do you prefer?
Ben.
Ben. Okay. I prefer Daniel when people talk to me, but in a lot of places people just automatically default and call me Dan, and I say that's, you know, or even Danny, and I say that's not my name. And my son's name is Ben, and we wanted him to be called Ben and not Benjamin, and so we just named him Ben and not Benjamin. And lo and behold, people still will say, "Oh, Benjamin," and he's like, "No, that's not. It's not just that I would prefer to be called Ben. It's that my name is actually Ben. It's not Benjamin." And so we've trying to avoid this fate that I've had where people shorten my name by giving him the name that we want people to call him, and yet people still call him the other version of the name from time to time. So we will call you Ben. And we got Ben and Daniel in this. So so tell me what's going on in the White versus Brown case.
Well, Jesse, is it lied or Lide?
I say lied.
Lied. She was a widow, and she lived with her sister-in-law and her niece at her estate for 25 years, I think they said, until she passed away. And she had 9 siblings, but only 2 survived. And they quit claimed any interest they might have had.
Do you know what that means?
I assumed it meant that they just forfeited any interest in the estate.
Yeah, that's pretty much it. To quit claim an interest is to say, like, I might have an interest, but I'm giving it to, in this instance, I think they gave it to Evelyn. Okay, so they may have had an interest in this property, but they said we're out. Okay.
Okay. So that her heirs at law would be her nieces and nephews that survived by her.
Mm-hmm.
And I think she said there's 12 of them. And but in her will, she said that she leaves Evelyn White her home to live in, but not to be sold. And it says that she leaves her personal property to Sandra White Perry,
Mm-hmm.
who's her sister-in-law and her niece that were living with her. And at the end, it says, "My house is not to be sold again." She reiterated it.
Mm-hmm.
And so the issue that they're discussing here is whether or not it's a fee simple given to Evelyn White or a life estate.
Do you think that Jesse Lyde has seen my chart for possessory interests?
Oh no, she wrote her own will, so the word her intentions might not be well stated.
Yes. So I don't think that she has seen my chart either, and I think that this is fairly typical and common, that people draft wills without knowing precisely how to word what they want to happen. So Ben, let me ask you, what do you think she wants to happen with this house?
I thought that she wanted Evelyn to have it, and I couldn't really tell whether or not what she wanted to do after
Mm-hmm.
Evelyn passed away. It seemed like she put it in there to keep it in her family.
Even after Evelyn has passed.
Right.
And so, and what is the language in this conveyance that is making you think that?
The fact that she put in a condition at all, the fact that she put limitations on her conveyance.
Right, but what is the limitation that she put on it?
Alienation.
Right, don't sell it. Right, not
Right.
to be sold. She says it twice. I wish Evelyn White to have my home to live in and not to be sold. Blah 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 blah. My house is not to be sold. So, do you think that she wants the house to be sold?
No.
No, it seems pretty clear. If there's anything clear in this, it seems that she doesn't want the house to be sold. Did you pick up? Has the house already been sold in this case?
Well, at the chancellor that I was at the trial level,
Mm-hmm.
he ruled that due to the house's condition in accordance with all parties, that it was to be sold and proceeds distributed.
Yeah, it's already been sold. So, on some level, that ship has already sailed against Jesse's intent, but it really doesn't answer the ultimate question, which is what precisely did Jesse give to Evelyn? Ben, if she wanted to give a fee simple, what should she have done if she was looking at my chart?
Not put any restrictions on it, just convey it to her.
And it just said to Evelyn, period. And if she wanted it to be a life estate and her nieces and nephews taking it after, then what should she have said?
Specified that she wanted her nieces and nephews to have it after Evelyn's life.
Right. So what would that look like? So I'm now making you the lawyer for Jesse and saying, I want you to craft a will that gives it to Evelyn for life, and then after that to the nieces and nephews.
Just almost exactly that. I would say I want my estate to go to Evelyn for her life, and then to my heirs.
To my heirs or to my niece and nephew. I could name people specifically, whatever, right? So to Evelyn for life, comma, then to nieces and nephews, something like that. That would make it clear. What we have here, unfortunately, is something that is a little more ambiguous than that. So the Alex Perkins, the nieces and nephews are saying that what came out of this will from Jesse?
I think they're saying the nieces and nephews are saying that could you be more specific?
What interest was created for Evelyn out of this will, according to the nieces and nephews?
The interest is for Evelyn. The interest for them or the interest for Evelyn?
Well, the difference is going to be made based on what Evelyn gets. We know Evelyn is getting something out of this. And so the question is, what does she get? The nieces and nephews have one theory for what this gives to her, and Evelyn has a different theory. So the nieces and nephews think that Evelyn has received what?
A life estate to
Which would
hand it on to them when Evelyn dies.
Correct. So if it's a life estate and we go to our chart, that means there has to be a future interest given somewhere else. Right. And they, as the heirs, are saying that they would be the recipient of that future interest. Are they mentioned in this will at all?
No.
No. So this is a situation in which the future interest, if it's a life estate, the future interest has not been given away. So it's as though, if that's what you wanted to do, right? So Ben gave us one example where she's explicitly giving a remainder to the nieces and nephews, to Evelyn for life, then to nieces and nephews. Here, what she's done, it seems more close, if the nieces and nephews theory is right, is that she has given the life estate to Evelyn, and a reversion has been kept by Jesse's estate. Okay, so it's just a to Evelyn for life, period. Okay, which creates a life estate to Evelyn and a reversion to Evelyn's estate, to Jesse's estate. And since the nieces and nephews are the inheritors, are the heirs to Evelyn's estate, to Jesse's estate, they are the ones that would take that reversion. Okay, so that is their theory. And then, of course, Evelyn's position is that what was given to her, what interest?
A fee simple.
A fee simple. So the court has to resolve this dilemma. Do we take this language and say it is a fee simple, or do we take this language and say it is a life estate? And Ben sort of had a thought that, it seems like maybe it's less than a fee simple because there's this restrictive language on it. What do you think if you're looking at that?
Yeah, it looks like the part of the will to Evelyn is a life estate because it's the requirement of her living in it, and to live in something necessitates actually being alive.
Mm-hmm.
So,
so that language suggests to you there must be some limitation on it. And are there limitations placed on fee simples?
No.
No, it lasts forever. There's no real limitation that can be placed on it. A fee simple is the best, and this is something less than the best. So you think also that this looks more like a life estate?
Yes.
Okay. What does the court conclude?
The court also concluded that it was a life estate.
Are you sure? Ben, you want to help him out?
Sure. Yes, they said it was a fee simple and pretty much ignored the condition she put on it. Just took it out.
Okay.
Yeah. So Alex, did you find somewhere in there where you thought that maybe the court had found that it was a life estate?
It's not that. I was reading what the court found, and it was a bit confusing to me.
Mm-hmm.
And
there is a dissent in this case.
Okay.
And the dissent does find, or would have found, that it was a life estate.
Oh, yeah, that's right. Harbison's dissent. That's where I got it from.
Yes. So if there is ambiguity in a conveyance, right? So unfortunately, not everyone has memorized my chart, and sometimes people make conveyances that are ambiguous as to exactly what they mean. Then we're stuck trying to figure out, what to make of it. And Alex, what is the sort of, the court, both the majority and the dissent, give us a variety of ways in which we go through that, but they tell us that the primary thing that we're trying to do is in interpreting these ambiguous conveyances is what? What is the sort of driving thing that we're using to get to our answers?
Whether or not there are limitations.
Okay, so that's part of one of the I'd say that's like a second level. Like we're looking at, okay, what did the grantor do with this conveyance? Cooper, the sort of guiding principle here in terms of interpreting an ambiguous conveyance is what?
They looked at the language in Green v. Young, and both.
Okay, so we've got other cases. We got other cases that might help us and say, like, in other cases they've done this, but maybe Ben, you can help me here. The sort of driving principle when we're looking at a conveyance is what?
Are you talking about the intent of the grantor trying to do that? And are you talking about the
yes.
rule?
No, just stop.
Oh, okay.
Yes, I'm talking about the intent of the grantor, right? Remember when we're doing conveyances, Cooper, what do we have to have in order to have a gift?
Intent, delivery, and acceptance.
Intent, delivery, and acceptance. And what we need to figure out is what intent it is. right? And so when we are looking to ambiguous conveyances, and conveyances are just gifts, we're looking at what precisely was the intent of the grantor. What did they mean to be giving away? And so that's why we had this dialogue about what do we think Jesse wanted to happen with this property? Did she want it to be a fee simple where Evelyn could do whatever she wanted with it? If so, then why'd she keep saying don't sell the house? Or did she want it to, as one of you guys articulated, go to Evelyn for life, but then keep it in the family after Evelyn had died, which would be a life estate with some sort of future interest attached to it? Which one did she seem to want more? That's what the court is saying their goal is to try to figure out. And so, Cooper, I don't know if you recognize this. So you pointed out the precedent, right? So one way to solve this is to say, in other cases with similar language, this is what we've found. So tell me a little bit about those other cases, the ones that you have identified.
So the court in Green v. Young, the testatrix's disposition, it said that to be used by him for his support and comfort during his life, and they decided that that conveyed a fee simple through that, even though there was ambiguous language there as well. And
yeah,
so
Alex pointed out that this language "to live in" suggests that you are living, and if it is only going to be an interest while you are living, well, then that would be a life estate. But Cooper, you're pointing out, like in other contexts, during life, right? Or I forget exactly the language from that case. That language was present. It would seem to suggest the same thing. Yet, the outcome was that it was a what?
They said it was a fee simple. Towards the bottom of 230, they said that Mrs. White does not evidence such a clear intent to pass only a life estate. And so rather they said it was a fee simple interest for her.
Great. Okay. So let's talk about that last point. She doesn't evidence a clear intention to pass on a life estate. So both the majority and the dissent are using what are called rules of construction. Okay. They're both using rules of construction. These are not really rules in the sense that, like, don't break them. They are guidelines that courts utilize in order to construe what a will means or what a conveyance means. Okay. So Cooper, right there in that section, they're talking about that here we have an ambiguous will. The choice is either a fee simple or something less than a fee simple. And they're giving us a presumption, and they're saying, like, generally speaking, if it's ambiguous, we presume that it will be one thing unless there's a clear intent that it is the other thing. Which is the presumption that they say ought to apply in such circumstances where it's either a fee simple or it's something less than a fee simple?
They said that, so her attempted restraint on alienation, I guess, was pointing more towards her conveyance of her intent of a fee simple more so than a life estate.
Okay, well, so let's hold off on the restraint on alienation for a second. We're going to come back to that. But if the choice is between fee simple or not fee simple, the majority seems to be saying, which one do we prefer?
They prefer fee simple.
Why? Why? I mean, I don't know if they tell us why. Why would you think that we would prefer a fee simple over a life estate?
I think life estates seem a little bit more confusing, especially in the case at bar, because if there's not a fee simple, then it would go to Evelyn's life, and then there would be complications as far as, you know, let's say the heirs have passed away, and dividing that up between the remainder would probably be more difficult.
Exactly, right? It's a fee simple, you know, it's simple, right? Like don't mean that to be silly. Like, it is much easier for us to deal with fee simples because we don't have to wait for anything else to happen in the future in order to distribute this property out. Cooper, if I'm trying to sell a fee simple or sell a life estate, which one do you think I'm going to have an easier time selling?
Selling a fee simple would be much simpler.
Definitely. If and as the Baker case kind of points out, trying to sell something that's saddled with a life estate and remainder is really, really tricky. You might even need to go to court if you can't get agreement among all the interest holders. You might have to go to court to get that sold. Selling a fee simple is easier. Let's say Evelyn moves onto this property and wants to take out a mortgage. Is she going to be able to, in order to pay for, either a home improvement or pay for somebody's college or something like that? Is she going to be able to get a good loan using her life estate as collateral, or which is she going to be able to get a better loan, using her life estate as collateral or using a fee simple as collateral?
It'd be easier for the fee simple.
Much easier.
I have a quick question. If it was a life estate, I feel like she wouldn't have much interest in improving the property itself as well, because she doesn't have pure possession of the estate at that point. She knows it's getting passed down.
Exactly.
So she virtually would have no interest in improving it, or I guess adding anything to it.
Yeah, I don't know that I would go so far as to say she had no interest in it, because she does have to live there.
Right.
But let's say she's getting on towards the end of her life, and the choice is either like make an expensive repair to the house or just deal with it until she dies. Like, she has every incentive not to spend a lot of money or make a lot of investment in improving this property, because she can't control it after she dies. As opposed to if she had a fee simple, she would be able to, obviously she still can't enjoy it after she dies, but she would at least be able to control where it goes. So it's a good point. Another reason why we tend to say, and the majority is pointing out, where there's ambiguity, we favor fee simple. Okay. Cooper, let me stick with you. If it's a life estate, has she identified where it would go afterwards?
She did not, and the defendants are arguing. Can you hear me?
Yep.
Sorry. She did not, and the defendants are arguing that it would go to interstate succession, in which they are the heirs, because it would have passed to, well, they're her nieces and nephews, and I believe that's involved in heirs rather than being an issue.
Yeah. So you're right. And their argument ultimately is that this is going to pass to them through intestate succession. So I've pulled back up the will. Do you think that this will meant to capture everything that Jesse Lyde owned?
I think that I took the language to, or I would say that the ambiguity is more skewed towards the Whites and Sandra as well. I know that she wasn't an heir, but it so she left her home to Evelyn, and then basically all of her personal property is how I took that to mean to Sandra.
Yeah.
So it sounded like she was really leaving everything in their possession.
It seems like the only two people that she wants to get any of her stuff are Evelyn and Sandra. And in fact, the circumstances of their lives suggest this, right? They had lived together for a long period of time, and the language in the will itself seems to suggest, Evelyn, you get this, Sandra, you get everything else, and by the way, don't sell the house. So, leaving that part out, it seems like she's clearly intended to give away everything that she owned, and specifically give away everything she owned to these two individuals. So the only way in which the nieces and nephews have a claim in this case is if she has accidentally left out things, right? And so they're arguing that what has she accidentally left out in terms of her estate? She has conveyed they're arguing a life estate to Evelyn and all her personal property to Sandra, but what has she accidentally retained?
So they're saying that she didn't leave a remainder and that she left a life estate to Evelyn. Therefore, they are a third party future interest in the remainder.
Right. That she, and it was actually, it would technically be a reversion what they're talking about, but yeah. And so the court is saying, no. Well, maybe that's one way of interpreting it, but it's also arguable what Cooper has just said, which is that it seems like she wants to give everything to Evelyn and Sandra. And so why don't we, we have these two choices again, like when we're talking about maybe it's a fee simple, maybe it's a life estate. We have a presumption in favor of the fee simple because fee simples are so much easier. Here, we have a choice between she gave everything away or she gave most everything away, but accidentally retained some things in that will pass intestate. And so the court says, no, we have a presumption unless there is obvious intention in the alternative, we have a presumption not in favor, against partial intestacy. Where there is a will, it is presumed that that will gets rid of everything, unless there is some obvious retention of something. Okay, so we have a presumption in favor of fee simple, which says it's going to be a fee simple. We have a presumption against partial intestacy, which says it's going to be full, everything is contained in this will, and nothing passes just through intestate succession to the nieces and nephews. Okay, and so the court is using that, along with, as Cooper has identified, some other cases in order to get to its conclusion that this is a fee simple. Okay? All right. But the dissent disagrees. So Alex, I'm going to come back to you. They are interpreting this exact same language, and they say, well, yeah, okay, there's a presumption in favor of a fee simple and a presumption against partial intestacy, but the language that the dissent is focusing in on is what? There is some unambiguous intent contained in this that the dissent picks up on.
Yeah, that's the end of the third sentence or second paragraph, talking about the home needing to be lived in and not being sold.
Not to be sold, underlined and repeated. Don't sell the house. And
Yeah.
so,
Even in
go ahead.
this, that's just after about property left to someone else. So yeah, the fact that she put not being sold twice is pretty apparent.
Okay. And so it's a presumption in favor of fee simple unless there is a clear intent otherwise. And the dissent is saying there is a clear intent otherwise. She's saying clearly, don't sell my house. Don't sell the house. And so that suggests that it is not a fee simple. Okay, and if it's not a fee simple, the only other possible interpretation based on what we have here is it's a life estate. And so one thing that the dissent is utilizing is a separate rule of construction, which says don't ignore any words in the will. In other words, don't make them useless. Okay? The result, Alex, if it's a fee simple, is what with regard to that language, don't sell my house?
It's an ignoring or disregard of those words.
Disregard, it's a meaningless sentence. Okay, and so we presume that they didn't put anything in there that they didn't want to have some effect. Here, in order to get to the majority's conclusion, they have to ignore the don't sell my house thing, which, by the way, she said twice and underlined. Okay, and so the dissent is saying that's a different thing that we, a different principle that we use in construing wills is don't make language irrelevant. So that's a different rule of construction. So just so everybody's with me, a main point of this case is to see how this operates in action, but also to start identifying these potential rules of construction that might have to be employed. And so we're just seeing them, right? We're seeing them in action. There is another rule of construction that the dissent uses. And so, Alex, I'm going to walk through it with you. This language I also leave my personal property to Sandra White Perry. Okay. What does that do for the personal property? What does Sandra White Perry get in terms of sticks?
She gets, I guess, the personal property equivalent of a fee simple, because there's no indication or limitations on what she can do with that personal property.
Great. So, and in fact, the personal property equivalent of a fee simple is a fee simple. So these interests are applicable both to personal and real property. So she's giving Sandra a fee simple to the personal property. So what does that tell you about whether let's compare now the personal property and the home. So it seems clear that she's done here. She actually has seen my chart, right? It's just a to Sandra. Okay. To Sandra. That's a fee simple. Okay. How does that compare to what she did with regard to the home?
Well, in regard to the home, she puts a limitation and a requirement twice specifically, and no such limitations exist to describe the personal property for Sandra.
So there's limitations on the real property and no limitations on the personal property. And so what does that suggest? Does that suggest that she wants them to be kind of the same kind of interests created or different interests created?
Different interests.
Right. And so this is another rule of construction, which is called apt language, where language is used to create an interest in one place and different language is used to create a separate interest elsewhere, we presume that the grantor intended different things or different effects. Okay? Where language is used to create an interest in one place, to Sandra, fee simple, and different language is used to create an interest elsewhere, to Evelyn, to live in and not to be sold. We presume that the grantor intended different things in those two situations. One, she clearly intended a fee simple. Two, she clearly intended something other than a fee simple. And since she intended something other than a fee simple, it must be a life estate, and therefore the dissent says the nieces and nephews are holding the reversion in this particular case. And so, Alex, you're more convinced by the dissent?
Yes, I am.
Okay, and is there any particular one of these rules of construction that you are particularly convinced by?
Don't ignore any words in the will, because it looks like the justification for the majority opinion is that they ignored that part of the words when declaring the house to be awarded as a fee simple, and that's just like laziness or incompetence or unacceptable, in my opinion.
Okay. So let's talk about the not to be sold language. Ben, what does the court say is wrong with that language? So Alex is upset because they're ignoring this clear intent not to sell the house. And again, let's point out they've already sold the house. So this is just a matter of what's going to happen with the money. And so, maybe that changes things a little bit. It shouldn't in terms of the law. So how does the court get around this? They say what about that language?
Well, they say that, let's see. They say it's not sufficient evidence of her intent to convey a life interest, so as to overcome the default position of a fee simple. And
so they ignore it. And is there a justification for ignoring that particular language, right? It doesn't say to Evelyn and, you know, I hope that she uses it as a residence, or to Evelyn and I hope that she will always allow my nieces and nephews to stay there also. It says to Evelyn and not to be sold. Is there anything in particular about the not to be sold that is problematic according to the majority?
Well, yeah, they said that if you're conveying a fee simple, you're unable to put any alienation restrictions on it at all. So it shouldn't apply because they assume she's conveying a fee simple.
Great. And so the problem that they're identifying here is that there are restraints on alienation. And if you recall, the whole reason we have this system of estates is to make alienation easier, to make sale easier. And I think with Cooper, we talked about, is it easier to sell your life estate or is it easier to sell your fee simple? And he said, without hesitation, it's easier to sell your fee simple. And that's exactly right. And in fact, there is policy against any sort of restraint on alienation like this. And so in order to get to the answer, Alex is right, they have to ignore this language. But there is policy justification for ignoring this language no matter what. Even if it is a life estate, they might ignore the don't sell my house, or at least don't sell the life estate language as well, because of this preference against, so I'm going to put it up here, rejection of restraints on alienation. Not to be sold is a restraint on alienation. And so one of the notes after the case talks about why we don't like restraints on alienation, partially for some of the reasons that we've already talked about. You can't use your property as collateral as easily. You might not, to pick up on a thing that we covered on last class, creditors might not be able to reach your property if there is a restraint on alienation because you don't have a right to convey, and therefore creditors can't reach it in order to satisfy debts that you've accumulated. It also, the book talks a little bit about, it also prevents people who are irresponsible from losing their property, and sort of has the effect of perpetuating the sort of wealth, you know, in a family, despite maybe irresponsibility by that family. And so there's all these reasons why courts and really, you know, sort of the property regime more broadly does not like restraints on alienation. So I want you to hear this loud and clear. We don't like restraints on alienation. Even if you like restraints on alienation, the American property system does not like restraints on alienation. The only place in which you really see restraints on alienation enforced broadly is in the landlord-tenant context, and maybe many of you have been involved in situations like this where you wanted to get out of your lease and you maybe wanted to assign your lease to someone else so that you could move into a different place or leave town or something like that. And there was a clause in your lease that said, I thought I was sharing screen. Am I sharing screen? No. I added this up here. There is a clause in your lease that says you cannot assign your interests without the landlord's permission. Okay, and so that is an example of a restraint on alienation that is enforced, but generally speaking, restraints on alienation are disfavored, are not enforced. They might be if they're for a limited time, like if it had said to Evelyn and not to be sold for 5 years, or if they're limited in scope, right? So if it said to Evelyn and not to be sold, let's say outside the family or something like that. So there are situations in which sort of partial restraints on alienation will be included, will be validated, but generally speaking, we disfavor restraints on alienation. They are rejected. They are not included. Okay, let's open for questions on this case. Or we got it. We knocked it out. Yeah, Jack.
I was just kind of curious. So when they decided it was a fee simple, and she took it, I just can't forgetting her name right now. It's with her now and her family and her heirs. So like, there's no way that could come back to the family line of Evelyn or sorry,
Of Jesse?
Yeah. Mm-hmm.
I mean, if Evelyn wants it to, then Evelyn can make that happen, but not through the will of Jesse.
Okay.
Evelyn holds a fee simple, and really she doesn't. Again, maybe it's worth pointing out. All we're talking about here is how the money's going to be distributed. Evelyn gets all the money from the sale, as opposed to having to split the money between Evelyn and the nieces and nephews. So
Okay.
Here we're actually dealing with money instead of real property, which maybe makes it a little bit of an easier case.
Thank you.
Austin.
I didn't really pick up on if the court addressed this, but is there a way that it could have been a life estate with a remainder interest to Sandra because Jesse left her personal property to her?
It is possible that would have happened. Let me share again. Had the will said something a little bit different, had it said, I also leave my personal property and the residue of my estate to Sandra White Perry, in which case she would have said, Sandra gets everything, right? Everything else Sandra gets. But in the absence of that language, the fact that she has called it her personal property in this particular sentence is undermines that interpretation of the will, because she has specifically identified personal property, and any reversionary interest in this would be in real property, and so it's not captured. Is that making sense?
Yes, thank you.
Okay. Alana?
I was just a little bit confused about something we had talked about earlier, which was the nieces and nephews argument that since the remainder wasn't addressed in the will, that it should follow through the intestate succession, because by definition that succession occurs when there is no will. So I was just a little confused how they could argue for that when there actually was a will.
Yeah, so it is possible to be partially intestate. So it doesn't mean that there's no will. It means that there's no will that determines what happens with this property. So let's say I had, I don't know, 2 houses. And in my will, I clearly identified what happened to the first house, and that was it. That was all I said in my will. I didn't say what happened to my, any assets that I have, or what happened to the second house, or whatever. In that instance, it would be clear that I willed the first house to whomever I willed the first house to. But it would also be clear that I didn't say anything about any of my other stuff. And so I would be intestate as to that stuff. And so sometimes this happens when a will is outdated. So you might have created a will at a time when you only had some assets, and so you account for what happens to those assets. And then as you accumulate new assets, you don't update your will, and you actually leave yourself partially intestate. So one of the rules of construction is that we presume that you haven't done that, left yourself partially intestate. But if the facts of the will are such that there's no other way to interpret it than that you are giving away only some of your assets through the will, then we do have situations in which there's partial intestacy.
Got it. Thank you.
Okay. Anybody else? We good? All right. So we'll do Baker, and then we'll start to move into these defeasible fees, the other possessory estates on Monday. Okay? All right. I'll see y'all later.
Yes, sir.
Yes.
I was just curious. And I know you're busy and stuff, so it's cool if not. But could you like post something on your page, like like 3 more just practice problems that we could do on our own time, and maybe confer with you on them?
We're going to.
Okay.
Yes,
Thank you.
definitely.
Yes, sir.